children under the age of 18. Okay,
Thank you, Your Honor.
thank you. Keep those. Robert Lowe, Ms. Holmes.
We redid paperwork on him, to do a cap.
Okay,
So Judge, because it didn't, generally I would send the dismissal, but I didn't know if you wanted to take some time with this, or if we accepted
Yeah.
this. We'd done it before and it got rejected, so I didn't go ahead and do the dismissal.
so if it's a cap, we're gonna, I didn't get a precedent, I
We
already
Did
have
a
a
one.
PSI,
precedent
but it was
report.
for deferred probation, it was
Right.
rejected.
And there was a memo,
And then the sister sent the memo.
Yeah, I mean, I can take a minute and kind of refamiliarize myself with that if y'all want to do it today, or do you anticipate, do you want a week or two to come get anything that you want together for
Yeah.
me on sentencing since it's a cap now?
Yeah, that week should be
best for,
fine.
whatever's best for the court that week.
Okay, let's do that. So I'm just gonna, that way, and just remind me to look at that again for sentencing. We don't need anything updated. He's been in custody the whole time.
Right.
So let's just reset it a couple weeks at the most. And so, Mr. Lowe, I'm just gonna reset your sentence, your case. Let's go ahead and go through the pleas though today, and then we'll reset it for sentencing, but without an updated pre-sentence report. We'll do it that way. All right, give me just a second. And I've rejected it, so we've got to go through all of it again, so. And again, you're Robert Lowe. And Ms. Holmes, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor,
All right, let's see, we're going on
the
this
first
one.
three.
First three, Judge.
3 possession cases, 3 files entered into the system. The judge verifies every detail, while part of the indictment is dismissed through a plea deal. Calm tone, controlled delivery, but the gravity is clear. Child exploitation charges don't leave this courtroom without permanent consequences.
Number 19-32660. You're charged with a third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? And then in cause number 19-32661, you're also charged with the third-degree felony offense of possession of child pornography from June 4th of 2018. And how do you plead to that charge? And again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? And then finally, in cause number 19-32662, you're charged with the third-degree felony offense of possession of child pornography from June 4th of 2018, and how do you plead to that charge? Sorry. And again, are you pleading guilty freely and voluntarily, and because you did what they've charged you with? In all 3 of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 6 years in prison, which means if I follow the agreement, I cannot give you more than 6 years. I could give you 6 years, I could give you less. It'll all depend on any other information that's brought to me and the information that I already have when we come back for sentencing. You have an absolute right to have a jury determine 2 things. The first is to determine if you're guilty or not, and then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving your punishment up to me within that range of the cap. And is that what you want to do? Okay. And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Lowe is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing just so that we can all get back up to speed on it. If there's any other information you think is important for me to know, get that information to Ms. Holmes and she'll present it to me on your behalf when we come back. Also, it is part of the plea agreement. It looks like that the state is going to dismiss cause numbers 19, 32663, 32664, and 32665 as part of that agreement. All right, we'll see you back at sentencing. You can go back with the bailiff. Yes, sir.
There's no chance I get probation?
It's still an option.
It's still an option?
Yes,
I
it's-
misheard.
You can get anything from 6 years down to 2 years. Probation is on the table, or you're legally entitled for me to consider that, yes.
No, I just misheard. That's why I was asking.
Okay, yes, sir. You can go back with the bailiff. See, Mr. Lewis, you have David Dark. We're gonna also reset Mr. Simon, Ms. Malfino, for Mr. Rojas, so he can go out and go over a little more information with him. And then this is Mr. Coleman Fontanet. Good morning, sir. You Caden Fontanet? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Fontanet, in cause number 25 DCCR 1759, you're charged with the first-degree felony offense of aggravated robbery from October 10th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And it looks like there is no agreement in this case.
That's correct, Judge.
But y'all marked out one thing, but then signed it that, so the post-conviction waivers, y'all marked out. But on the admonishment, you put that it's a plea bargain and he has a right to appeal. So if it's unagreed, he has a right to appeal. So
David Chapman pleads guilty. The judge confirms every detail, prior felonies, understanding of rights, consequences. No drama, just finality. 3 years in Texas prison, firearm ban, no appeal. One calm voice ends the case, and his freedom disappears with a signature.
maybe even a minute. It's so cold in here. It's gonna cold. Thanks. So it looks like there's no agreement, which means you're leaving your punishment up to me. And that range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand? What'll happen is, if I go forward today, I'll go through this plea and then I'll reset your case for sentencing. The probation department will do a pre-sentence report. And then at sentencing, Mr. Coleman, Mr. Rojas can put on any information or evidence that they want. And then I'll make that decision. Do you understand? You have an absolute right to have a jury come in and determine two things. First, you could have them determine if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do? Do you want a jury or do you want me?
You.
Okay, so you're waiving your right to a jury, right? Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Fontanet is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. Like I said, we'll get that pre-sentence report done, and then we will come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Rojas, and he'll present it to me on your behalf when we come back. Do either of you anticipate a long hearing or just a normal day? We should be fine. Okay, we'll see y'all back at sentencing. Mr. Fontanet, I don't know that we checked today or not. I just want to let you know something real quick. But for sentencings, we always get jail incident reports. So I don't know what you've been doing, hopefully nothing. But if you have been acting up and getting incident reports in our jail, it better stop today. Because I'll look at all of them, and if there's reports, when you come back, it is very unlikely that you're gonna get a whole lot of anything out of me as far as low end of the punishment range or probation or things like that if you can't follow the rules out there, okay? Okay, we'll see you back at sentencing. Yes, sir?
Mr. Fleming has decided to accept the plea bargain agreement.
Okay, as soon as it comes through, I'll take care of it. Thank you. Thank you, ma'am. Have we seen Mr. Vasquez? Let's go back. Ms. Holmes on Maryland Close. Good morning, how are you?
I'm here.
You're one of those mornings?
Yeah, this morning. DWI warned at 6:30 this morning. Who was drunk at 6:30 in this weather?
The last time that I
It's
sang,
from last night. I'm not saying
last time I was up, I had more in the morning than I had in the middle of the night.
it's crazy.
Yes. I'm like, go home and stay home. Don't leave again.
But I'm like, it is too cold outside.
I know. Yes, I had the same issue. It was weird. Good morning. Are you Maryland Close? This is 25 DCCR 1220. Ms. Close is charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, the state made an offer for today, today only of 18 months. State jail, Ms. Close has informed me that she intends to bond out today. And to take care of her case, she states that she has some medical concerns that she's trying to get taken care of as far as surgeries involved. And so she's indicated to me that she plans to bond out today.
So, Ms. Close, that's, if you want to reject that offer, that's fine. I know y'all talked about it, and Ms. Holmes has explained to you the position of the state. That's between y'all. If that plea agreement is out there later, it is. If it's not, it's not. I also want to make sure you understand, if you bond out, you will be expected to at least try to hire a lawyer as well. If you can't afford one, we'll go through a process, and then you might still qualify for a court-appointed. But if you make a bond, I want you to at least start trying to talk to some lawyers about hiring them, okay? So I will reset your case. If for some reason you don't bond out or whatever happens, talk to Ms. Holmes. She's still your lawyer until we determine otherwise, and she'll be working on your case unless you hire somebody else, okay? All right, you go back with the bailiff. Maryland Close. And then you've got Mark King, 3 cases.
I had filed motions for a bond reduction on him
Oh, I don't see that. When did you file it?
last week, this Thursday or Friday.
Okay. That's fine. It just doesn't say it on the, Did you get a copy of those? There were, okay.
We've discussed this, Judge.
For some reason, he doesn't comment on the jail roster. Is it because of the type of case?
Because he was certified. This is so, Judge, it's very confusing. He's an adult now, but he was certified for something that occurred 10 years ago when he was 14 years.
Gotcha. So that could be it because it was that. All right, are you Mark Anthony King? And so Mr. King is charged in cause number 25, DCCR 1063, 1064, and 1065 with aggravated sexual assault of a child. The bonds, it looks like, are they all set at $250? The bonds are currently all set at $250,000. Ms. Holmes has filed a motion asking for me to reduce those bonds. And just based on what you guys were just saying, it looks like offense dates were from 2018 and 2019. Mr. King was a juvenile at the time and has now been certified. When I say at the time of the offense as a juvenile, but certified to stand trial as an adult at this point, correct?
Yes.
We're all on the same page. Okay. Mr. Nichols, before we go too much into it, what is the state's position with regard to bond?
I don't have a huge objection to a reasonable bond, Your Honor. This case involves allegations with an 8-year-old girl, or 8-year-old at the time. It was a delayed discovery, delayed outcry. In all candor, I've had trouble getting in touch with her family, and so I don't know where this case is going to end up at this point.
Was there, what was the relationship with
It's
the
a
alleged? A cousin, okay. So, Mr. King, where will you be living if you make bond in your case?
With my sister.
With your sister? And what, do you know the address?
1489.
Is it Beaumont? Is it Port Arthur? Is she here?
No, cause I talked to his mom.
It's in Beaumont.
It's in Beaumont. What's your sister's name?
Raven Wilson.
Raven Wilson? Okay. Does Raven have children? How many?
Five. I just had one more.
How, that's gonna be a problem.
You can't stay with your mom?
So here's the thing, based on the nature of these allegations, at least while your case is pending, if I reduce those bonds, you're not gonna be around any children under the age of 18. So do you have another option of where to live? You'll have to ask your mom? Okay, so let's do this. I'm not opposed to reducing the bonds, but I need to know that there is a place where there are no children under the age of 18 with someone who's willing to make sure kind of that happens. We don't need to have a hearing necessarily. I'll make the conditions of that. I'll likely have a GPS monitoring device and understand that that's a financial issue. So I'll take that into consideration on the amounts and also what Mr. Nichols said about the complaining witness and some difficulty.
And we'll continue to do our job, Judge. It's just at this point, we haven't been able to make contact.
Okay. And is it the same complaining witness in all three?
There's 2 complaining witnesses in the three cases.
Okay, all right. And are they the same?
Same rough age.
Family.
Yeah, two of them
But
is the same person, they just had 2 different dates.
But the two complaining witnesses, what is their relationship to each other?
They are cousins.
They're also cousins.
Yes.
Everybody's cousins. Okay. All right. So, yeah, get me that information. If you'll just send an email, Ms. Holmes, to Mr. Nichols and I'll let y'all know together what the amount is and what the conditions are, as long as there's a place that is for sure with you. Tez?
Judge, on this, we have an agreement on him, so I wasn't sure if I actually did the right paperwork. It's just
It's MTRP, so it could have just lined through that first page.
I'll mark through the first, and actually the top of the second as well on MTRPs. I always mark through them if y'all don't.
I wrote MTRP.
That's perfect. Thank you. Good morning. Are you David Dartez?
Yes, ma'am.
And will your client waive the formal reading of the motion?
He does, Judge.
Mr. Dartez, in cause number 22-39677, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 11th of 2022 for the offense of theft of property, a third-degree felony, and that was a 6-year deferred probation. Is that correct?
Yes,
The motion alleges that you violated your probation. Count 1 alleges that you failed to report to the State of Louisiana Community Supervision and Correctional Department March, April, May, June, July, and August of 2024. And is that true or not true?
yes, ma'am, it is true.
Okay. Count 2 alleges that you failed to report by mail or online to Jefferson County, Texas, October, November, and December of 2022, January through June of 2023, September of 2023, and then November and December of 2023, and then January through September of 2024. Is that true or not true?
Yes, ma'am, that's true.
Count 3 alleges that you provided a urine sample October 10th of 2024 that tested positive for marijuana. Is that true or not true?
Yes, ma'am, that's true.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
Yes, ma'am, that's true.
Count 5 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
Yes, ma'am, that's true.
And then count 6 alleges that as of October 10th, 2024, you were $650 behind in your fees. Is that true or not true?
Yes, ma'am, that's true.
Did you enter your pleas of true to counts 1 through 6 freely and voluntarily?
Yes, ma'am.
And because those counts are true?
Yes, ma'am.
All right, I have here on the tablet some documents that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am, I did.
Do you fully understand them?
Yes, ma'am.
And you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue you on probation, likely extend, and order that you enter and successfully complete ISF. Which program?
Cognitive track.
And probation's here. Thank you for being here, sir. Is this also what you believe would be appropriate for Mr. D'Artes?
Yes, Judge.
Okay. And so is that your understanding of the agreement?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted any evidence that Mr. D'Artes is not competent.
No, Judge.
Any reason not to go forward today? All right, Mr. D'Artes, it looks like everybody's willing to work with you and give you a chance to be successful on this probation.
Yes, ma'am.
The number 1 thing is you got to show up. You've got to do your reporting online and in person. It looks like you tested positive for marijuana one time, which is obviously we don't want you doing, but we don't know what you're doing if you're not showing up. So in my opinion, you probably were doing that a whole lot more and just not showing up. If you continue to violate and not show up in person, not show up online, test positive again, and you're back in court on a motion to revoke, it's not going to go this smoothly. Do you understand?
Yes, ma'am.
So I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I'm going to extend your probation by 2 years. You didn't show up for a while, so you're going to get more probation. In order that you enter and successfully complete the ISF cognitive track. And then it sounds like some type of aftercare, substance abuse, depending on where he is, would be appropriate. So if he's back here for some reason, JCDI. If not, and he ends up back in Louisiana, some program like that for any type of drug issues. So I'm handing you the trial court certification that shows this.
A probation violation hearing turns serious fast. The judge reviews the original theft case and the new violations. One decision could erase second chances instantly. No raised voice, just legal authority. When probation fails, the courtroom doesn't negotiate. It enforces.
Mr. Lewis, I'm going to take care of one quick plea, and then I'll get back on yours.
Oh, no problem.